Hi, and welcome everyone to Know Your Law. This is a small initiative to let everyone aware of various important and essential laws of our country. Each week, we try to bring to you an essential provision of one of the many acts in our country. Hope it will help you, if not today, but maybe sometimes in your life. So today we will be dealing with, or we will know about, when police may arrest without a warrant. So the first question that comes to mind is there any provision under which police has been given the power to arrest without warrant? Yes. So section 41 of the Code of Criminal Procedure 1973, also known as CRPC, empowers the police to arrest without warrant. So what are the grounds for arrest? When can a police actually arrest without warrant? So the provision states any police officer may, without an order from a magistrate and without a warrant, arrest any person who commits in the presence of a police officer a cognizable offense. So two words are very important here. One is the presence of the police officer and second is the cognizable offense. Now what is a cognizable offense? The first schedule of the CRPC deals with classification of offenses with regard to offenses under the Indian Penal Code, IPC. So here each offense is classified either as cognizable or non-cognizable. So basically cognizable offense is all those offenses where police officer may arrest without warrant. Now what happens when police officer is not present? Police may arrest a person against whom a reasonable complaint has been made, or credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offense which is punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years with or without fine. But there are certain conditions which needs to be fulfilled. Firstly, the police officer has reason to believe on the basis of such complaint, information or suspicion that such person has actually committed the said offense. Secondly, the police officer is satisfied that such arrest is necessary. Why? 1. To prevent such person from committing any further offense, or 2. For proper investigation of the offense, or 3. To prevent such person from causing the evidence of the offense to disappear or tampering with such evidence in any manner, or 4. To prevent such person from making any inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the police officer. And 5, as unless such person is arrested, his presence in court whenever required cannot be ensured. And while doing all this, the police officer shall record everything in writing while making any such arrest. Now, a person can also be arrested against whom credible information has been received that he has committed a cognizable offense punishable with imprisonment for a term which may extend to more than 7 years, whether with or without fine or with death sentence, and the police officer has reason to believe on the basis of that information that such person has committed the said offense. So that means police has the power to arrest any person whom he suspects to have committed a cognizable offense, whether it might be punishable for 7 years or more or with death sentence. Everything comes under this purview. Police may also arrest a person who has been proclaimed as an offender either under this code, that is CRPC, the Criminal Procedure Code, or by the order of the state government. Police may also arrest a person without warrant in whose possession anything is found which may reasonably be suspected to be stolen property and who may reasonably be suspected of having committed an offense with reference to such thing. Or police may arrest a person without warrant who obstructs a police officer while in the execution of his duty, or who has escaped or attempts to escape from lawful custody. Or police may arrest a person without warrant who is reasonably suspected of being a deserter from any of the armed forces of the Union, or someone who has been concerned in or against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists of his having been concerned in any act committed at any place out of India, which, if committed in India, would have been punishable as an offense, and for which he is, under any law relating to extradition or otherwise, liable to be apprehended or detained in custody in India. So that means any offense which is committed outside India, which had it been committed in India would have been an offense, and the place where the offense has been committed, India has an extradition treaty with that place. So police may arrest that person without warrant. Next, police may arrest a person without warrant who, being a released convict, commits a breach of any rule made under subsection 5 of section 356 of CRPC. What does section 5 of section 356 state? It states that the state government may, by notification, make rules to carry out the provisions of section 356 relating to the notification of residence or change of or absence from residence by released convicts. And lastly, police may arrest any person without any warrant for whose arrest any requisition, whether it's written or oral, has been received from another police officer, provided that the requisition specifies the person to be arrested and the offense or other cause for which the arrest is to be made, and it appears therefrom that the person might lawfully be arrested without a warrant by the officer who issued the requisition. So this is nothing but a delegation of duty. So that is it for today. We will meet again next week with something new and interesting. Till then, stay safe and remain aware of your rights and laws. Thank you.